it stops, no one knows. We're going head into the unknown. Na, 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 na.
We are on the record. Good morning.
Good morning, Judge. I'll say good morning since Nick didn't.
Good morning, ladies and gentlemen.
I echo that. Good morning.
Glad to have you here, Nick. Thanks for joining us. Good morning, ladies and gentlemen. Welcome to Carroll Circuit Court. As Officer Bodie has indicated, my name is Fran Gull. I am a judge in Allen Superior Court in our criminal division up in Fort Wayne, Indiana. I am serving as a special judge in the state of Indiana versus Richard Allen, 08C01-2210-MR-1. I was appointed on November 3rd of this year by the Indiana Supreme Court by Chief Justice Rush. I will show that the defendant is here in person with his attorneys, Mr. Bradley Rosie and Mr. Andrew Baldwin. The state is here by the elected prosecutor, Mr. Nicholas McClelland. We are here today on the state's verified request to prohibit public access to a court record that was filed with the court on October 28th of 2022. Before we begin, I just would like to inform those of you present here in the courtroom of the courthouse management and decorum order that was entered for this hearing November 22nd, that I entered with the court on November 18th of 2022. The attorneys received this order so they know what to expect. And you've already, ladies and gentlemen in the gallery, experienced some of the directives. Only one entrance to the building was open. You were searched, your bags were searched. If you have a cell phone here in the courtroom, again, please ensure that that cell phone is off and no other electronics are permitted in the courtroom. I will tell you, consistent with my practice in Allen Superior Court, if your phone goes off, I will have it confiscated and it will be destroyed. Ladies and gentlemen, please remain seated throughout the proceedings. As we go through this hearing this morning, if you must leave, please do so quietly and please do so with the least amount of disruption possible. Once the hearing is concluded, I would ask that you remain seated until the parties and the court have left the courtroom, and courtroom security indicates that you may leave. Mr. McClelland, on October 28th of this year, the Carroll Circuit Judge granted your verified request to prohibit public access to a court recorder and ordered the charging information and the probable cause and other court documents sealed and deemed to be confidential court record pending public hearing. That order scheduled November 22nd at 9 a.m. to be that public hearing. Under the Indiana Rules of Court, the rules on access to court records that were effective January 1st of this year, the burden is on the state of Indiana to demonstrate by clear and convincing evidence that the requirements of Rule 6, Paragraph A, have been satisfied. Since we are proceeding under the Indiana Rules of Court, the rules of access to court records are not applicable. The Access to Public Records Act under Indiana Code requires the state to proceed under the rules of the trial rules. So we will be proceeding under that. Therefore, no public testimony or comment is necessary, as that is only required under the Access to Public Records Statute, Title V. So, gentlemen, are you ready to proceed?
Yes, ma'am.
I'll say yes, Your Honor.
All right. Mr. McClellan, you may proceed.
Thank you, Judge. As the court mentioned, the state did file a verified request to keep the records confidential, and specifically the probable cause affidavit and the charging information. The state's proceeding under Rule 6, and what Rule 6 says, Judge, is in extraordinary circumstances, if the state showed that the public interest will be substantially served by prohibiting access, or the access will create a substantial risk of substantial harm to the state or other persons, or the general public, or that a substantial substantial prejudicial effect to ongoing proceedings cannot be avoided without prohibiting access, the court can restrict access to those records. As the court said, the burden's on the state. I must show by clear and convincing evidence. Clear and convincing evidence. Not that at least one of those requirements are met. Doesn't have to be all of them, Judge, just one. And then if the court does decide to keep the probable cause and charging information confidential, the court's required to do so in the least restrictive means necessary. So, Judge, in that effort, I have decided to present a couple of exhibits for the court to consider. I presented those exhibits to the court. I want to go over those exhibits, Judge. I presented those to the defense. I have in court today as well. Exhibits, what's been marked as State's Exhibits 1 and 2, Judge, those are affidavits from, Exhibit 1 is ISP Detective Jerry Holman, and Exhibit 2 is from the Carroll County Prosecuting Office Investigator Steve Mullen. They've both been involved in this case for several years. They have intimate knowledge of the details of this case. They both believe in their affidavit that releasing information would jeopardize the ongoing investigation. The next exhibit, Judge, is, what comes after? State's Exhibit 3, that's a letter from Becky Patty. That is Liberty German's guardian. She's in favor of keeping those records confidential as well. And then, Judge, Exhibit 4 is an online petition that serves not only the county, the state, and the nation. There's over 40,000 signatures on that petition, also petitioning the court to keep the records confidential. State's moving to admit those 4 exhibits, Judge.
Any objection from the defense?
No, ma'am.
Jody, I'll have you mark those as State's Exhibits 1, 2, and what comes after 2 again? 3?
That'd be 3, Your Honor.
Thank you. As reflected by Mr. McClellan, please, and show those admitted without objection.
Thank you, Judge. Judge, there's not a lot of precedent for a hearing like this. I've searched high and low for case law, talked to several people. There's just not a lot of precedent. This is an unusual situation, an extraordinary circumstance, if you will. The state is confident in the evidence that's been presented in both the probable cause and the charging information. We're confident of that evidence and of the contents, but I am concerned. I have 2 concerns: the continued investigation and then protecting the witnesses involved in that case, Judge. Those are my 2 main concerns. It's my job as prosecutor, in part, at least, to enforce the law in an effort to protect the community. The first concern talks about the integrity of the investigation. And I think that falls under the public interest factor and consideration for the court. This is still a very ongoing investigation. Our goal is to find anyone else who was involved in this heinous crime. That is the public interest, to find anybody else involved and get justice for Abby and Libby. We still get tips every day. Tips come in every day. We have good reason to believe that Richard Allen is not the only person involved in this, that there may be other actors involved. That's why we left the tip line open. That's why we left the tip email open. The question becomes, at least in the state's mind, is it more important to release the details of the investigation to the public, or more important to keep those confidential in order for the investigation to continue and find anyone else that's responsible. The public has an absolute right to the information. I don't deny that, Judge. But at what cost? This rule was designed for extraordinary circumstances where the court can limit that access. The state believes that this is one of those extraordinary circumstances. Keeping the public, keeping the record confidential serves the public interest. It puts an investigation in the best position possible to determine if anyone else was involved. It is in the best interest of the public that the investigation find anyone else involved. The second part that I'm concerned about, Judge, is the safety of the witnesses and other people involved in this case. We have seen the extraordinary lengths the media has gone to in order to get the next soundbite or the next clip for their broadcast. We are a society of people that has a right to know. Social media, Facebook, Instagram, all the rest. We want all that information right now immediately. The media has went to great bounds to interview anybody involved with the case. Mr. Allen's wife, Mr. Allen's old neighbors in Mexico, they've staked out his house. They've went to these extraordinary circumstances to get anything they can involved in this case. Even by Richard Allen's own admissions, a letter to the court asking for a public defender. They forced his wife to move and abandon their home. We also know that prior Judge Diener recused himself by his own admissions to an email to the court judicial staff. He had concerns for his safety, for his staff due to the facts surrounding the arrest, so much to the point where he felt it was necessary to get out of the case, Judge. And so the state believes these are real concerns for the witnesses and the people involved in this case. Look at the amount of security we have here today, Judge. We don't have to protect everyone here today. We can't look at this case like any other case. This is an extraordinary case. By its nature, the state believes it's important and allowed under Rule 6 to keep the PC and the charging information confidential. Not only to protect the integrity of the investigation, but also to protect the witnesses in this case, Judge. So the state respectfully would ask the court to continue to keep the PC and the charging information confidential. However, if the court deemed that those items would be released, the probable cause and the charging information, I would ask the court to consider redacting the witnesses' names to protect their identity and the people involved in the case. Excuse me while I get myself a sip of Dr. Pepper. I switched from Mountain Dew to Dr. Pepper this week. I'm trying to cut down on caffeine. Hang on.
Good luck with that. Good luck with that, Nick.
Thank you for your court's indulgence. I would ask the court to consider redacting the witnesses' names, protect their identity and the people involved in the case. In an effort to do so, Judge, I have redacted charging information and probable cause. I'd like to submit to the court for their consideration. It has the names of the witnesses and people involved in the case redacted, Judge. And if the court's so inclined at this time, I'd like to at least admit that to the court, not as an exhibit, but as for consideration for the court to consider a redacted version as opposed to releasing the entire document.
So, Mr. McClelland, is there a page 8 that you might have still? I think we skipped over the entire page 8.
Oh, good Lord.
I mean, it really did.
Oh, you're on my notes. I forgot something.
Perfect.
Can you go back to a lot? Okay, hang on. They didn't teach us this in law school, Your Honor. And okay, so I'm gonna go back to the very bottom of 6. The question becomes, at least in the state's mind, is it more important to release the details?
No, the bottom is 7.
Yeah, go to the bottom of 7. We missed the entire 8.
Yes.
Oh, I missed 8. We don't have. Oh, there we go.
Interestingly, it
Okay,
worked.
got it. We don't have
It did work
a
still.
lot of security in Carroll County, but I will tell you, my tenure here, I've never seen the display of law enforcement that we have here today. This is a highly publicized case. We had countless meetings over the couple of months or past month about security, how to get Mr. Allen in here, all the safety of everybody involved in the case, Judge, and that should extend to the witnesses and should extend to the other people involved in the case. The court can imagine the media pressure, intimidation, and evidentiary issues that may arise in the name of the witnesses if the name of the witnesses are released and those witnesses are subject to constant harassment and bombardment by the media. A little more Dr. Pepper. The state also has concern that there may be The state also has concern that they may be interviewed on 6 o'clock news and their testimony will be taken as such. That causes evidentiary issues. Some of the witnesses were juveniles at the time. They are now 19 and 20 in their first and second year of college. They need to be able to focus on what they're doing in school and not be worried about the constant harassment from media. And I'll remind you, Judge, some of the witnesses are still juveniles. And so there's concerns there. And again, Judge, the burden is on me. I have to show by clear and convincing evidence. And so the gauge starts at the presumption that the information should be released. And I have to convince you to move that ticker far enough to keep it confidential. And so, Judge, I looked up clear and convincing. We don't deal with it a lot. We deal with beyond a reasonable doubt. So I looked up the jury instruction for clear and convincing. The jury instruction says the facts supporting the claims are highly probable. Look what we have here today, Judge. The chaos, the amount of attention this has drawn, the concern for safety. Defense counsel, the state, everybody had a concern for safety for themselves, for Mr. Allen, for everybody involved. Went to extraordinary lengths to protect everyone here today. Now, I'm sure you remember what I said a little bit earlier, rambled on a little bit about integrity investigation, go on. And the court's so inclined at this time, I'd like at least submit to the court, not as an exhibit, but for your consideration, for the court to consider a redacted version as opposed to releasing the entire document.
Any objection, gentlemen?
No, ma'am.
Okay, thank you. I won't mark this as an exhibit. This will be my work product, so it's not available to anybody other than myself and my staff.
Thank you, Judge. Apologize for that little out of order argument. As I said earlier, I switched from Dr. Pepper to from Mountain Dew to Dr. Pepper. Obviously, it's impacted my thinking. So, Judge, I'm about done. I wanted to leave you with one last thing. As I said, I did a lot of case law research to find any support for my motion and or anything that is not in support of my motion. I came across a case, Brown versus State, Indiana Supreme Court case. It's from 1969. It's old, but I wanted to read you a quote from that case because it's kind of hit home dealing with the circumstances that we have today. And the court says this: the right of the news media to fairly and accurately report the news, the right of the defendant to a fair trial before an impartial tribunal, free of influence of generated prejudice and inflamed passion of the community, and the right of citizens to fully comprehend and analyze the administration of the court system are elements necessary to the attainment of justice. Elements necessary to the attainment of justice. If any one of these rights fall, the rest will surely fall. And the term justice, excuse me, all worked up. This brings tears to my eyes. Elements necessary to the attainment of justice. If any of these rights fall, the rest will surely fall. And the term justice will become hollow and meaningless in our constitutional system, unquote. Judge, again, the state's asking that you keep those things sealed. I appreciate the time here in court today, and I appreciate you allowing the state to have entered exhibits and make an argument. Thank you, Judge.
Well, thank you, Mr. McClelland. Mr. Rosie.
Thank you, Nick. Judge, let me just start by saying that Mr. Allen in this case seeks transparency. It seems to me that, in the normal course of operations in our courtrooms around the state, that's what we get. That's the norm. And really, there's no reason in this case to sway away from that. I would point out first, if I could, direct the court to the pleading that was filed on October 28th, 2022, the verified request to prohibit public access to a court record. This pleading, if you look at it, is deficient on its face, and I would direct the court specifically to the fact that Rule 6A specifically says a verified written request to prohibit public access to a court record may be made by any person affected by the release of the court record. It requires a verification, and a verification in our business is that word is a term of art, as you know. IC 1145 codifies the very essence of what a verification is. And what you're going to find, and I would direct the court to Smith v. King, it's a little dark in here, frankly. 716 NE, blah, blah, blah. It's a 1999 case involving an election dispute. Specifically, Head Note 3 of that case addresses what a verification is and what the minimum standard to meet that verification is. And it says, when applied to pleadings, verified means supported by oath or affirmation in writing. Pursuant to trial Rule 11B, it's sufficient if the petitioner simply affirms the truth of the matter to be verified by affirmation or representation in substantially and following language. And it says, quote, I/we affirm under penalties for perjury that the foregoing representations is or are true, end quote. The essential purpose of a verification is that the statement be made under penalty of perjury. And it cites Austin v. Sanders 492, and I'm not reading those. This document contains no verification which references that that it's been signed under the pains and penalties of perjury. So I think it's facially deficient, and I would ask the court to consider that before we even get to the rest of this. And of course, I can offer up the case to the court, but I know you have the citation, so we should be good. Moving on, we get to we can all hear you. Sorry. We get to the
Mr. Rosie, please don't talk to Mr. McClelland like that. We know we can hear him.
We get to the access to public records statute, IC 51431, open door law, all those kinds of phrases that get thrown around in our practice. And what I would say to you is that, when I look at this statute, I was actually surprised to find that the very first section, 5-14-3-1, the first chapter, codifies public policy. And I think that's extremely rare in our practice when you actually see a statute that essentially codifies the public policy. And I'm not going to read the whole thing, Your Honor. You've probably already looked at it, but the first sentence says, a fundamental philosophy of the American constitutional form of representative government is that government is the servant of the people and not their master. It sounds like something Thomas Jefferson wrote, frankly, but more importantly, you get to the last sentence and it says, this chapter shall be liberally construed to implement this policy and place the burden of proof for the non-disclosure of a public record on the public agency that would deny access to the record and not on the person seeking to inspect. It says two important things. One, liberal construction, which means it pertains to many documents in our judicial system. And two, most importantly, it places the burden of proof on the state in this case, which Mr. McClelland has already acknowledged. And that burden of proof is, of course, the clear and convincing standard. So I think the point I'm trying to make here is that the legislature felt so strongly about the disclosure of public records that it actually codified the public policy. I just think that's really unique. And one of my counterparts that I practice with would say that's pretty cool. It's just not the kind of law that we're used to seeing. So moving on, this Rule 5 is kind of the driving force here, actually, in this access to court records arena that we're in. And the Rule 5 basically says that, exclusion up front is, or I'm sorry, that transparency up front is where the court ought to be with this, and only under extraordinary circumstances should the court deviate from that. And that word extraordinary is the second word in Rule 6 too, by the way. And what you see, if you read through these rules, is that there are a lot of terms that are used to just really bolster and beef up that burden of proof. And I think they just speak to how important it is that we have transparency in this community, in this system, I should say. And that's no different in this case. So let's get to Rule 6. Mr. McClellan hit on a couple of the bullet points, one being that the public interest is substantially served by prohibiting access. Again, another strong word, substantially. Disclosure of the records will create a significant risk, again, a significant risk of substantial harm to the prosecutor, other persons, or the public. Disclosure will work some prejudicial effect on the ongoing proceedings. So all strong words, again, consistent with the clear and convincing standard. Let's touch on the first one specifically. Will the public interest be substantially served by limiting access? And Mr. Allen's position is no, it will not. It's exactly the opposite. This is a case where the crime occurred over 5 years ago. It's taken almost 6 years for an arrest to be made. Time and public resources have been exhausted over that scope of time. Those are almost impossible to quantify. And any secrecy involved in this investigation, in my opinion, and Mr. Allen's opinion, has done nothing but increase the hype and the public interest. I mean, it's the idea that the public has known very little is what has caused, all this attention to occur. And so by continuing that pattern or allowing the state to maintain this confidentiality, I think we're just perpetuating the problem. My suggestion is that the opposite would happen if you unseal the records. And that is to say that the public can see the truth regarding the facts that support the allegations in this case. They can see where the expenditure of their tax dollars has gone. And, Mr. McClellan talks about the second prong here, and that the release of the records will create a significant risk of substantial harm to the prosecutor, other persons, or the public. At this point, I don't want to sound flippant, but what's the risk? I mean, we've all just walked in here today, with security and the right safeguards in place, and we're fine. There are a few juveniles referenced in the affidavit, and I do understand that may play a little bit larger role in the court's opinion today, just trying to protect those individuals. And, frankly, Mr. Allen, the defense doesn't have any problem with redacting some names of witnesses and things of that nature that might serve a purpose. But, I haven't heard, and nor have I seen, any of these exhibits that were introduced by the state, any actual references or appreciable threats that have occurred. In other words, we didn't hear John Doe or, Jane Doe come in here today and tell you that they received a phone call from an anonymous person last week with a, threat on their life. I haven't heard an officer say that he or she that their lives have been threatened. I think a lot of this is just driven by the social media aspect of this. You can get on Facebook any day of the week and find somebody threatening somebody. Not that I don't take those things seriously, but, it's like fast food. Most of that doesn't have a lot of quality to it. It's just quantity. And I haven't heard any evidence today other than some argument about the law, which actually supports the idea that there are any appreciable threats on anybody involved in this case. And so, any suggestion at this point regarding this second prong, that there will be some significant harm to the public or people involved, I think is just conjecture and speculation. Moving on, there's a practical problem here too. And the practical problem is if the court orders these records to remain confidential, we are going to be forced to walk into this courtroom and delicately dance through all of the factual scenarios in this case because the public's going to be sitting behind us. And that doesn't seem to make any sense. It seems to make things more difficult. You're going to have people reading between the lines. All this stuff's going to go down in print. And then you're going to have all these, the public trying to decipher what we did and didn't say and what we're inferring. And, it makes our job way more difficult. I would argue that it's going to make Mr. McClelland's job more difficult. How do we talk about law and facts in a bond hearing? We've got a bond motion pending. How do we talk about law and facts in a suppression hearing? How do we talk about law and facts in a hearing on change of venue? All those things, which are pretty customary in cases like this. The public would be sitting right here the whole time. And so it just doesn't make any sense practically either. And I'll just finish with this. The burden, again, we've talked about the clear and convincing evidence. I haven't gone back and counted. I didn't, do any internet searches before I came in here today, but over the last 5 years, I have some very ingrained memories of state police press conferences in this community. I don't know if there were 2 or 4 or 6 or 8 or 10. I frankly don't know. It seemed like a lot. And, in my mind, for the state to come in, for the state to be a part of that process of having public press conferences, releasing composites, things of that nature, and asking the public for help, and then to turn around today and suggest to the public, we don't really want you to see what's here. It's kind of like talking out of both sides of your mouth. I mean, that's the way I view it. And I think that's the way Mr. Allen views it. And, we think that the standard is extremely high here, clear and convincing evidence. Nick gave me a little crash course on what the Black's Law Dictionary says. What I know about clear and convincing evidence is, for those of us that practice in civil court from time to time, it's the standard that we employ when we're trying to terminate somebody's parental rights, which I think is pretty darn high. And to say that the state has met that burden in this case, I think is just not accurate. None of these documents that you have seen have any information in them which suggests anything with detail that somebody's in harm's way or that some other suspect is, out there and needs to be apprehended. It's just conjecture. And we would ask that you unseal the records, if you will, for for lack of a better phrase, and let's move on with this. Thank you.
Any response, Mr. McClelland?
That's pretty cool. No, Your Honor.
Well, gentlemen, I really appreciate your excellent oral advocacy. I will take the petition under advisement to review the exhibits that have been submitted, the case law that's been argued by counsel, and issue a written ruling in due haste. I know that this case has generated a lot of public interest, and I know that the attorneys and Mr. Allen deserve this court's attention as quickly as possible. I know with the holiday coming up, will not interfere with my ability to review my notes and the exhibits and issue a written ruling. Mr. Rosie, you and Mr. Baldwin did file a motion or a petition to let bail. Can we set that for a hearing while we're all here today?
Yes, ma'am.
So that we can get that matter resolved? Are you looking at this year as well, or?
I'm thinking January. Is that?
You're thinking January?
Yeah.
Yeah, that's fine. I'm out the first week in December, and then we have a jury. Oh, that's not me.
That's Nick.
You asking me, Judge? Well, I head to bail every December. So I'm at a jury trial. I got a jury trial here December 12th. So December is kind of, I don't know.
Okay, I got it. I got it.
A shot from the state's perspective, Judge. So I'd be looking at January as well.
Okay.
I think my biggest concern is just, frankly, giving Mr. McClelland's office some time for him to get us some of the basic discovery and us being able to have a little time to sort through it.
I was going to ask you about that.
Yeah.
I know that the prosecutors indicated it's pretty much an open file discovery policy here in Carroll County.
It sure is, Judge. It is wide open.
You've received what? Anything?
Well, just the PCA affidavit.
Okay. So you don't have any of the formal discovery from the state of Indiana?
Yeah, I don't know what the volume is going to be like, so I don't want to get ahead of ourselves on the scheduling side. I wouldn't even have a problem, Andy, early February even. Is that reasonable, or am I?
Mr. Baldwin?
No.
Late January, early February?
I would like some time to.
Are there any particular days of the week that work better? I'm looking at the first week in February then, if that's what you are all talking about. This is my calendar for the next 2 months.
Judge, I will be in a murder trial down in southern Indiana the first week of February, so that would not work for me.
So that won't work for you. Okay. What about the second week? I'm in a murder trial every week, so just so you know. Like, I have murder trials every day, all day. Every week.
Yeah.
All year long.
Let's see here.
So, second week of February then?
I'm more open than it sounds like than the court. Second week of February is fine with me.
Not knowing how long that trial is going to last, if we're going to do the second week, I'd prefer like the 10th. It should be completed by then. I'd hate to continue it.
Okay, I was looking. So, you're looking at like the first full week, the 10th?
Friday?
You're saying the 10th.
Right.
I don't want to jam you up. I mean, if that's not a good day, we can go to the second, the week beginning February 14th.
I would actually prefer that because I'd like to come out of that trial and have time to prepare for
Okay.
the hearing. I appreciate it. Of course, I also have another murder trial scheduled that week, but I don't think that's going to go. So,
What about February 17th? Will it take all day? Is that fair? A half a day?
I think we should set the day aside.
The day?
Just to be like until we get off and running here, we have a better idea of how quick the lawyers work and that type of stuff.
Okay.
I'm okay on the 17th. Nick?
That's fine.
yes.
All right. February 17th. Can we start like at 10? That way my staff and I don't have to get up that early.
Oh my God.
I'm fucking tired sometimes with all these murder trials I do every day, all day. My intent is to have as many hearings here in Carroll Circuit as possible. I have no idea what the calendar looks like for the sitting judge.
Sure.
We don't have anything on that date as of now, Judge.
Okay, as of now.
Well, I have the court calendar right here. I came prepared, unlike some other folks, maybe. Now, that obviously is subject to change, but right now there's nothing set that day.
Okay, so we could set it for February 17th, 2023 at 10 a.m. And I'll make sure that Mr. Allen joins us. I'll get a transport order, all right? I know that we have an Omni hearing in January. There's already been a trial setting, and it was my understanding when I spoke with the judge before, or after his recusal, that's interesting, that the trial setting is a first setting.
That's correct, Judge.
Which,
when the prior, sorry to interrupt the court, when the prior judge said it, he did set it as a first setting in March.
okay.
I'd say we just let it sit for now till we.
Sit.
Yeah, I mean, we're not setting aside the week yet, right? We just have the date on the calendar.
Do we have to change the omnibus date to let bond date hearing date?
I'm happy to do that if you'd like. Would that be easier for you?
I think that makes sense, but
I would, yeah, I think that's a good idea.
Okay, so cancel. Okay, so cancel January 13th. And we'll just do February 17th as a bond hearing and an omnibus hearing. And that's satisfactory to counsel, Mr. Rosie?
Yes, ma'am.
Okay. Is there anything else that we need to do on the record, Mr. McLeland?
I don't believe so, Judge. No.
Nope.
Mr. Rosie?
No.
All right. Thank you, gentlemen.
Thank you.
I appreciate your advocacy.
Well, thank you, Judge.
She didn't appreciate it for long.
Ladies and gentlemen, as I indicated, if you would all remain seated until the parties and Mr. Allen have been removed from the courtroom. There you go. No, you're going to stay seated forever.
And we know the outcome of this, that Nick didn't meet his burden and she released it.
Right, with the redactions.
Yeah, but then she released it with the redactions, but then he wrote a filing and it essentially copied and pasted the PCA and he did not redact it.
Right.
So I had a couple of things that stuck out at me. Number one, this is obviously the honeymoon period between defense counsel and the court. Number two, on page 14, towards the bottom, Rosie, like around line 20, pretty, this was prophetic. He's pointing out that, depending on what you keep sealed under the charging document and the probable cause affidavit, we're going to be forced to walk into this courtroom and delicately dance through all the factual scenarios in the case. The line 25, the public trying to decipher what we did and didn't say, and what over to 15 we're inferring, and it makes our job way more difficult. How do we talk about law and facts in a bond hearing? We got a bond motion pending. How do we talk about law and facts in a suppression hearing? Well, that kind of did rear its ugly head with Franks, and was the subject. A lot of what the first original action covered was about that very thing. That what was said in the Franks motion, and that got redacted and whatnot. And then in the original action, PFD, my nickname for the attorney that did the first original action, which had to do with public records and the Court Records Act, she went ahead and attached as an exhibit a completely unredacted copy of the Franks motion, just to show the court that you have no basis to redact any of this. And nothing, it's still to this day an unredacted copy is an exhibit in the that first original action. But I just thought that was very prophetic. The other thing he's trying to do, Rosie, towards the end on the scheduling, I mean, they have no discovery yet, and this was November 22nd. 0 discovery, and he's hinting at, we have no idea the volume, why are we? And then I think the court's like, are you sure you want to put a bond hearing off until mid-February?
Yeah, I ask about that. How does that make any sense? Why would we want? This is November. He was arrested in October. Why would we want a bond hearing in February?
Well, I think for a couple reasons, and she seemed to be a little taken aback by the fact that they hadn't received anything from the state either. Because, once they get put, once this is a case, if Nick is saying that it's basically an open file discovery and he's just going to turn everything over, you just like clicked the button and turned it over. So the fact that they hadn't had anything, I think took her aback a little bit because I don't think she expected it. And I think that they were just trying to be realistic about how much discovery, like what all about Richard Allen could have come through, like what all investigation they did do into him. And they didn't want to not be prepared. But then it was like nothing.
Yeah, I think that's right. Sleuthy, I think that's absolutely right. I think part of this, and it's hard with the, cold, dark record of just the words on the page, and why, we're going to try and at some point maybe get some audio recordings, because this really was a honeymoon dance. Nobody wanted to be firing the first salvo. They were getting a feel for the court, how the court was. So it's like, if this had been the second or third hearing, you'd say, well, that may be their policy, Judge, but they sure haven't opened the file for us. And what you would do is you'd turn to the DA and say, well, Mr. DA, I really appreciate the fact that you got an open file policy. When can we come into your office and look through your file? And you do that right in open court, but not at the, not during the honeymoon phase. You would get with the prosecutor after the hearing and say, hey, Nick, can we meet on this, kind of get some ideas on what's involved in this discovery? You're gonna make the file available to us in your office, and we can designate things for copies. How do y'all work your open file policy here? Because lot of prosecutors' office have open file policies, but their files are 1 inch thick.
Yeah.
So why did this hearing never take place?
Well, before we get there, I want somebody to clarify for me, because I'm a little confused. Now, didn't she say in that in-camera hearing when she gave them the boot that her issues with them started at this hearing in November 2022? Because if so, I'm a little confused of what the issue was.
Oh God, Nicole,
did she say that, or did she say that her issues with them began when they made the undated press release?
I'm gonna pull it up right now because I'm 90% of this hearing.
Thank you, Sleepy.
Yeah, of course she is.
I do find it very prophetic that Rozzy said, we've got a bond motion pending. How do we talk about law and facts in a bond hearing? Hey, what do you know? They didn't have a bond hearing. How do we talk about law and facts in a suppression hearing? Have they actually they didn't have a suppression hearing, right? That's what the Franks was about, correct?
Well,
or was one of the most recent ones that we had potentially a suppression hearing? It wasn't. That was in limine, right? I don't think we've had an actual hearing on suppressing anything.
Not that I recall. I think last June they heard the motion in limine regarding the gun and the unspent cartridge.
Okay. And I believe that's when she suggested a Frank's motion, correct?
Yes.
I've never seen that transcript from that June hearing, or maybe I did. I just don't remember.
Mr. McClellan, you were there.
All right, I found it.
They never followed through with it. So what happened was, it was supposed to be the motion to suppress, and it ended up being about the safekeeping. And then she said with the motion to suppress, you're going to need to deal with like the Franks. You're going to need to file a Franks.
Okay.
So it was scheduled to be the suppression hearing, and it never happened. And that was the June 2023.
And she told them to file a Franks, but I found it. So in the in-camera transcript on page 13, she says, I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of last year.
What?
Interesting.
What?
Keep going, or did she finish her thought on that?
Well, then she starts talking about dates in advance of this. She says, Mr. McClellan filed a motion for gag order, and we were in chambers, and you assured me, gentlemen, we don't want the media in our lives, and we will not try this case in the media, which literally can't be the same day on November 22nd, because he's arguing that he does want it all put out to the media.
Right. And let's just be clear. What day is it that McClellan goes ahead and makes a statement? Is it not the following day after this hearing?
Correct. It was the 23rd.
Yep.
So.
But she said
Okay.
her concerns began at this hearing, which...
What happened at this hearing that she would have any concern about? Their
I have no
scheduling?
idea. She thanked them for their advocacy repeatedly, so I don't know. I thought she said that, but now I'm confused.
I took what Sleuthy just read to mean that remind me didn't right after the hearing, Baldwin and Rosie released a press release.
December 1st.
Yeah, that was weeks later. And that was after Nick's press release the day after this hearing.
So,
Well, I mean, she does make the snide comment like Mr. Baldwin, like, I am in just an FYI, like, I have murder trials every week too.
I wonder if her concern was that they were waiting until February to have a bond here. Like, maybe she thought that it should have been sooner, but like at the same time, nobody was available. You know what I mean?
Nick wasn't available until January.
Right.
But I don't understand why. So
yeah, you know, I mean, if you got a shot at a bond hearing, if you've got a shot at it, okay, you're not, and so it's hard to get the context. Let's see, where is it? About page 20, 21. Where is she saying you're good with all the way out in February for a bond hearing? That's kind of what I'm getting, 18, 19, 20. Because if you've got a shot at a bond hearing, you'd be saying, well,
but Travis, what do they need beyond the PCA? Like, don't they need more information than just what's in the PCA in order to be prepared for a bond hearing? So I think it was more or less like,
no, you don't. All you need is the probable cause affidavit, and that actually would be good. But you know,
why isn't there a bond hearing happening right here, right now, at this November 22nd?
Right.
To do.
I think there's rules about how soon you can do it, and then you do have to prep a family member, and be able to have them to be able to come in on the stand and what a realistic bond, you know, they could make, and that, yeah, we've got this in assets, and we have our house we can put up, but in terms of cash that we can pay either a bondsman a premium for a bail bond, or cash that we can put up ourselves, you know, the most that we could realistically do is X amount.
then they technically really wouldn't have been able to do anything, because he was begging for a public defender, and she had to sell the house and leave. Unless she sold the house in preparation for something like that, and it just never came. like in preparation for selling or for doing bond.
Yeah, but truth of the matter is, you know, you're just not. You're not. No one's going to get a bond in a case like this. And so why they didn't do a bond hearing is, you know, they looked at the PCA, they started digging into it, maybe got some discovery in January, into February. And it was like, there's no way. To get to the root of things, where I think things got off track, is the judge had no comprehension of the vast amount of discovery in this case. Terabytes. She can list off all of the cases she's done and how quick she's done them, including death penalty cases. And I did this one in 4 days and this one in 6 days. Well, you know, a lot of murder cases are like that. Don't need any experts. It's pretty cut and dried and pretty straightforward. And yeah, you can do them in 5 to 10 trial days, but this thing, completely different. Don't think any of these folks have had anything to this magnitude. And I'm not talking about the media coverage, because this case, in terms of Indiana cases and big media cases, this is probably about 184 on the list of the top trials. Much bigger trials in Indiana. 100 times bigger than this. And so in terms of the magnitude and complexity of the case, I don't think anybody's run across it. And so she's used to, I mean, she's talking about an ombudsman hearing, which in Indiana, we don't really have that in Texas or where I practice, but it's a comprehensive, it's a day set for hearing for a bunch of different pretrial motions to be considered, like discovery. Where are things on discovery? You know, what have you asked for? What's the state said? You know, we don't think we have to give that over. And, you know, they fight about those kinds of things. And there's a list under that statute. And so she's talking about doing that. They're going to combine that in, what was it? They were going to do the February 17th, and we're going to do the bond hearing, and because they have a set schedule, and so they're just not communicating. Rosie's like, yeah, I think we just let it sit, and she's like, sit, and he's like, until the lawyers know how much stuff there is, how we work together. Is everything going to be a fight with the DA, or are we going to be able to agree to a lot? And Rosie's right on that. Until you know how things are going to go, it was real premature to be talking about scheduling on anything. I'm sure they were given an idea, maybe some preliminary discussions, you know, Nick, how much stuff is there? And well, you know, I got 25 boxes in my office plus 15 hard drives. I mean, there's a lot of stuff. Okay, well, and so I don't think the judge had any idea, and that she's thinking they're doing nothing, zero, between then and whenever the hearing was in June, if that's when it was, on the motion in limine regarding, thank you, Sleuthy, for getting that, by the way, in chat. Somebody asked about it, and I remembered it wrong. I thought the state filed a motion regarding its admissibility, but you pulled that up and posted it. The defense filed a motion, and not only was it denied, but she specifically ruled that the tool mark evidence on the cartridge was going to be admissible. I mean, that was a huge blow, and that may have been premature, but we'll talk about that another time. But and then things, like I say, this was the honeymoon, and then they started going from there. But back to what Sleuthy read from the in chambers quote, hearing, unquote, I don't know what she's getting at about concerns from November 22nd. The only thing I can think of is that either about the scheduling, that they weren't insisting. Well, Judge, I'm sorry if they've got a trial in December. We want a bond hearing in 10 days, and we'll go to Allen County if we need to. But I don't think they wanted it, and there's a lot of pros and cons in a case like this. Even asking for a bail bond when you just know you're not going to get it, it stirs up a lot of emotions in the community. There's a lot of good reasons why you wouldn't ask for a bond in this case, and you just would let it drop.
Well, what about the omnibus hearing?
I suspect that's back when they were emailing each other towards the end of the honeymoon period, I suspect. And I'm sure they emailed each other, and it's like, Judge, we've been working with Mr. McClellan's office, and they've gotten us 22 boxes of stuff. And we're going to submit motions. We're going to need to hire an investigator. We're going to need more resources to go through this information. And they just said, having an ombudsman hearing, it would just be senseless and a waste of time. Nobody's going to be ready for that. And it was taken off the calendar.
I'm sorry to interrupt you. For anyone in chat who is not aware of what an ombudsman hearing is, like myself, could you just let us know?
I've seen it in other Indiana cases, and all.
If you know, here, I'm going to look it up right now too.
From my understanding, it's essentially where the defense is saying, "Hey, we're ready to go to trial," or we've made an agreement, or they had initially, I believe it was March of 2023 was the first trial date. Like they're going to say, "Oh, we need more time," or we're going to be filing these types of motions. This is what we still don't have from our initial discovery. It's just kind of, it's almost like a version of
just a status hearing. Okay.
Yeah. But it's different because of what the contents of it are and I don't think every state has it. Am I wrong on that?
Well, I think Travis said they don't have that in Texas.
Yeah, okay. We don't have that. Instead, we just have a statute that if the defense wants to request a pretrial hearing, court has to set it. And then if you do get a pretrial hearing scheduled, you have to bring motions and you have to get rulings on those motions. Otherwise, they're waived. And not really having luck on, but every court seems like in their local rules that's one of the official settings. And again, that works for possession cases and felony cases. It works great for those that trials get set out about 6-7 months, and then 60 days before that they set it for an ombudsman hearing, which just means catch-all, but it kind of like a status thing. Where are you guys at? Are there, anything we need to take care of motion wise? And I'm sure there's stuff that you're required to have by that date. You're going to try and change venue, possibly pleas have to be done by then. So we have something like that in federal court. They call it something different. And basically, it's a time when you go in and they ask the defendant, have you gotten everything in discovery that you need? And then you either say yes or no. And then what's the problem? And judge gets that worked out, and that's about it. But in a more complex case, it's ridiculous. You have to break up those motions, and because they take a significant amount of time. The 3-day hearing was kind of that type of a hearing in a way.
Okay. Thank you.
You guys want to talk about the 23rd and secret hearing and public hearing?
Yeah, I'd love to hear your thoughts on that. What do you think?
I don't know if you have that available to pull up, Teresa, but
I'm sure I do.
So,
I'm sure.
Just for those who might not be aware, the court ruled on a couple of, she ruled on the Franks. One, she said they didn't make a showing, and so they weren't entitled to a hearing. And the other one,
we did that live earlier today, talking about those.
Go ahead, Teresa. I'm sorry.
I said we did a live earlier today talking about her denial of.
Oh, my apologies.
No, you're fine. I was just telling you so.
For those of you who don't know, watch Teresa's earlier video today. Don't listen to me because I'd get it out of order anyway. And I would just love to hear your thoughts. I wasn't invited. I wasn't invited to that earlier video, but
Me either, Travis. I only just found it before we came here.
YouTube actually gives you notifications and invites you and says, "Hey."
Well, you know how YouTube notifications are. I'm personally, I think I'm gonna dye my hair red because I'm beginning to feel like a stepchild. Anyway, so man, that's cool. That's pretty cool. She did a notice of hearing, and that was in the docket summary. And then Sleuthy and Teresa, like they normally do, they got the actual order. And it says that she's setting it for a status hearing. Doesn't really say anything beyond that, what the purpose is. And she says the first half will be not open to the public, something like that. And that the second half will be public. So we can talk about what we think that means. Did one of you all want to start first and talk about that?
Well, my thought was that it doesn't even start until 1. So I think that the closed part has to do with the jury questionnaires and any type of, evidence that they don't want to talk about publicly. But I don't think that's going to be really the case. I think it's going to come to the privacy of the jury questionnaires and what everybody's settled on with how they're going to question, like for voir dire or, that type of stuff, everything to do with the jury. And then I think what's going to open it is if whatever she hasn't ruled on prior to the date from the 3-day hearings. I think she'll talk about that. I think she'll talk about everybody's ready to go to trial. I think she'll talk about discovery exchange. If everybody's given over what they have, they're ready to go. Timing of trial, making sure that everybody's got the witnesses, that she's got the witness list, that just making sure everybody's on track for October. That's what I think. That'll be public.
What about Mr. Baldwin or Mr. Rosie? Y'all have thoughts on it?
Sorry, I'm also cooking.
What are you cooking?
I actually don't know what I'm cooking yet. I had a bunch of ground turkey that I needed to cook, so I'm thinking of 3 or 4 different things I can do with it. We'll see where the evening takes me.
It's like that show on the Food Network. They're given 5 ingredients. Make something out of this. Well, I salute you for being able to do that.
I can't do that.
A little of this, a little of that. So our hearings about jury questionnaires typically closed to the public?
I think that's the part that'll be closed. Yeah.
So with every trial, there's a basic questionnaire: name, address, do you live in the county? Are you currently under a felony indictment? General biographical information. Have you ever been injured in an accident? Ever served on a jury before? That's the basic stuff. And then Teresa got the jury questionnaire and she went over it. Again, didn't invite me, but I'm kidding. She did on that one. And, much more specific, much more focused on questions in the case, particularly what information they may have about the case, where they heard it, if they've formed an opinion, and then some other things, some scaled questions from 1 to 10, pretty standard stuff. From what I saw on some transcripts, like at the very end, about this, after they got the case back, March, April, I think Baldwin said, she said, well, I've sent out all of the questionnaires. They've already gone out. And the case, was going to be set whenever it was set for. And then Baldwin said, well, what about our questions for the questionnaire? She goes, I included all of them. And then, so those questionnaires get sent out, and the jurors are given a deadline to turn those in. They can either do it by email typically, or turn them in hard copies in person. And
I mean, it's Carroll County. I'm imagining they probably have to fill that shit in with the number 2 pencil, Scantron, and walk it down to the courthouse.
Yeah, you'd think, but I think aren't they doing juries? It's Allen County jury, and they're doing jury selection in Allen County, right?
Yeah.
Okay.
Yeah, that's correct.
I don't know if that's much more sophisticated there or not, but in any event, going over the questionnaires or discussing how that information, when they're going to get copies, who they get copies from, what the rules are about not letting that stuff leak, possibly that this lady Sleuthy Goosey better not have access to them.
I would
searching people on backgrounds, which, by the way, we bring in lay people and private investigators. We sometimes don't have that much time. We might get the questionnaires at 9 a.m. and we might start picking a jury at 1 p.m.
Exactly.
And we're talking a panel of 120, and one lawyer that if you just spent 1 minute searching is 2 hours. We typically have staff in there that are all covered under NDAs, that are searching social media, databases that we have about criminal histories and other types of things. And that's all legit. The state has all of that info at their fingertips, and they keep databases on jurors that are called but not selected. And so the state typically has a huge advantage on that because they have years and years of data that they save and collect. But I think, Teresa, you probably hit the nail on the head. That would be appropriate to have a non-public hearing on that aspect.
I have one more question about just about the logistics of that. So I think that was the March hearing where she said she had already sent out the jury questionnaires, and
Right.
Baldwin said, well, what about our questions? So clearly they had submitted questions previously and had these discussions, I'm assuming, by comments like that, except she didn't schedule a hearing that was closed to the public for that I'm aware of.
Well,
Correct? Maybe something more in camera or via emails, although I think at that point she was refusing to communicate by email.
Yeah, there was some sort of a hearing where they announced, whether that was in January or February, it may have been part of the contempt stuff.
Okay.
I think it was the long hearing. So they did contempt, and then they did the stuff where Baldwin was doing the part of the hearing where there were some social media people subpoenaed and others, and then they finished with that hearing, and towards the end said, okay, we're going to set this thing for March or whatever. I'm setting it for this many days. Okay. And then I'm pretty sure it was Baldwin said, well, what about the questionnaires? They're going out next week. What are all of our questions on there? Yep. I included them all. Okay. And I'm like, wow. So that was from the transcript. And I think Teresa and others reported consistent with that. Then fast forward to when there was another motion set, and it turned into, well, I'm not giving you guys 3 weeks. I'm giving you 10 days. The questionnaires have already gone out with telling them this thing's going to run this many days. And so they're, it's hard to say. I wouldn't judge anything from that a hearing wasn't set, that was private,
Okay.
that they got things back, because they may not have.
All right. I guess I'm just wondering, like, would these questionnaires vary wildly from the ones that were initially sent out previously, and would they need
I think they're probably the same. Just a different batch of people.
I doubt it. And see, it's going to go to a new panel. All those people, they're out. They draw new. So they would have all been notified. You don't need to show up on whatever day and time in Allen County. So multiple people reported, and Teresa's indicated, from the, I call them scriveners now, not note takers, because what they've been doing is really nothing short of remarkable. The ability to write down all of the information, picking out what they think's important, making sure they get that, and then between 2 or 3 scriveners, you have a pretty comprehensive idea of what the testimony was in these various hearings. But all of them, regardless of what position, that the tone of the court changed dramatically from the contempt hearing and the whatever hearing that was part of that 2 days that Baldwin argued. It just seems like there's been a major shift in the court's attitude towards defense counsel and all of that. And I don't know what the cause of that is or why there's a shift. I have a couple of theories, but seems like there's been a dramatic shift. It seems like the court's being more proactive. Not sure why that is, that scheduling a status hearing, moving this thing along, because I think what the court's objective is to give preliminary or final decisions on those motions and make sure, look, are we all on track for, what is it, October 29th or in October into November?
October 14th, I think, for jury selection.
Okay. So, and she's added another day, which would be for her to hand out the questionnaires to the attorneys at that time, the completed questionnaires. And that's maybe why she added a day early to facilitate. Yeah, go ahead.
So, well, Just a Bloke asked a question too, but my question kind of goes along with it. I think I have the answer to Just a Bloke's question. Would her decision on third-party suspects not affect the questions featured on the questionnaire? From the questionnaire we read through before, it does have things about Odinism and that whole situation. So that was already included on the first one. I don't think she would probably take it away. But I wanted you, from the legal side, so that people hear it, like kind of explain what Nick is asking for in a motion in limine to not have these certain things brought up, and how she can rule on that, where like what she can take away and say, nope, you can't bring it up at all, how she can incorporate like where they can say it, how they can say it, or like what types of questions can be asked. I hope that makes sense.
Yeah. So on a motion in limine, both sides usually file a motion in limine. You can file it way in advance, but both sides have like a standard set, and it's heard right before they bring the jury in, and kind of just go through them. And 99% of them, they did it in that, I don't want to say black swan, the Benefield case that was caught on the live stream, and 90% of them, the other side just agrees and don't want you making fun of us, Judge, and Judge, I'm not going to do that. And typically the response is, as long as it applies to both sides, Judge. And they just go through stuff that really the rules of ethics cover anyway, but it's kind of a reminder. And so there might be something, let's say it's a murder case and it's self-defense, and the state brings a motion, part of their motion in limine is not bring up the criminal history of the victim, person shot and killed. And the judge will say, were you were you planning on bringing that up in voir dire or in your opening anyway? And if they say no, if you say, no, I wasn't planning on bringing that up in voir dire or in opening, go, okay, then we can just table this, so to speak. And after the trial gets going and I can hear some of the evidence, and then I'll know better how it may or may not be relevant, the victim's criminal history. And that's just an example. So with Odinism, all of that, that's going to be real difficult, because if some of if what's his name, Click, and the other two detectives, if they're coming in, and not even third-party suspects, it could be just like Karen Reed, where they attack the investigation without getting into specific third-party suspects in the house, but that they didn't knock on the door. They didn't talk to anybody in the home. They didn't do any of that. That's attacking the investigation without saying this person in the home. So the judge initially, Judge Canoni initially granted the state's motion in limine for them not to mention any specific, they call it third-party culprit in that case. They were able to put on evidence to the point where they could point at the ATF agent that had an office in the Canton Police Department. What's his name? The ATF agent?
Higgins.
So they were able to get that on third-party suspect. Here in this case, you've got Click feeling so strongly about it that he sent a letter to the DA. And that stuff is typically fair game, bias of the investigation, incompetent investigation. If she said, well, I'm not letting anything about Odinism come in. I'm not letting anything about any of that coming in. They would have to work out, okay, well, what are we going to do? Redact Click's letter? Just seems really, difficult. But that's different than third-party suspect. They didn't cover, I don't believe, did they mention other individuals in that jury questionnaire? I can't imagine.
I'll go back and find it.
I'd be surprised that she would have included that, or that the state wouldn't have objected to that. But the way those questions are framed is, do you have any experience or know anybody, have a close family member that's familiar with Odinism or other similar things? McClellan covered a vast amount in that motion in limine, all the terms he wanted. Seems like there was 20 or 30 terms. It's going to be pretty hard for the court to weigh that and deny the use of any of those words in the questionnaire in voir dire questions. Might be fine to exclude it for opening until evidence comes in and she can make a determination. But the defense has a right to know what people's experiences are with things that could come up in the case. Just like, for example, they have the right to know is, any of the potential jurors a tool mark expert, have particularized knowledge in time of death and temperatures of bodies. There's a whole host of things that you're entitled to know about juries. You can't ask them, hypothetically, if you heard this, and this, would you convict? You can't ask commitment questions like that, but you can ask, do they have a family member in law enforcement, have a family member who works for ISC or the Canton PD? I just can't fathom that she's going to say, no, you can't mention any of these words in the questionnaire. It may be narrowing it down and trying to figure out, how we're going to take care of that. But that's really good observation on your part, Teresa, and sleuthy about not only most likely the non-public part of the hearings going to be about jury selection, going to be about questionnaires, going to be about how the motion in limine that the state filed about limiting the use of words and whatnot is going to impact with all of that.
I'm reading through the questionnaire right now just to double check and see what's actually. So it's asked, are you aware of the organizations or practices Sons of Odin, Vinlanders, Asatru, Norse paganism, or heathenry? If so, write an explanation.
I think she'd have a tough time. Striking that out. And then maybe what she wants to discuss is say, my plan is if anybody says, yes, I am. So the way you do jury selection in a non-capital case, when you bring in a bunch of people, you bring them in panels of whatever, 60, 75 at a time. And what determines that number, what determines it is the number of seats in that particular courtroom. And those potential jurors fill up. If there's 50 seats, then, they bring in 50 at a time. If there's 75 seats, they bring in 75. So you're asking questions and you see something on the questionnaire and you say, juror number 8, see, it says you have a family member that works at the DA's office. Can you tell me a little bit more about that? And it's in front of the whole panel. And so she may say, look, if someone answers yes on that and you have more questions, we'll bring them up one at a time. So everybody questions that panel. They're all sent outside the courtroom. And then if there's stuff that might be challenges for cause, like they read, they were actively involved on a YouTube channel called Criminality, and they were in there all the time. And they've solved the case. That's in their questionnaire. Well, you don't want to pollute the whole panel, so that everyone's questioned. Then they say, okay, juror number 9 who put this on their questionnaire, bring them in. And then, is it fair to say you've already formed an opinion on this? Oh, absolutely. Teresa on criminality, she's great. She's got this down. Well, where are you at on it? Well, I'm going to wait and see what the evidence is, but I think they got the right guy. Okay, you're out. So they bring them in one at a time, and she may just say, hey, look, if someone answers on that, we're going to do it in private rather than in front of the whole panel. Does anyone have an objection to that? And in death penalty cases, why it takes a long time to pick a death penalty jury is they're questioned one at a time. And so each side gets at least 30 minutes. And so you're talking an hour per juror. And so it takes a long, long time to pick a death penalty jury. And anyway, that's could be discussions about that. One thing I'm pretty confident in, it has nothing to do with plea bargain. I don't know if people had questions about that. I've been seeing that in the criminality
Yeah, a lot of people
chat.
think that there's a plea coming. There's a plea coming. Some are suggesting a plea deal. And so we did go over that too, the difference between a change of plea and a plea deal and how what each one constitutes. What are your thoughts on it in general? Like, do you think that Nick's offering up a plea deal, or do you think that there's Richard Allen's going to be like, all right, I see what's going to happen here, and I'm just going to go ahead and take a plea. I'm just going to change my plea.
So,
Well, then you would need
plea negotiation. Yeah, plea. I mean, that's possible that they offered him a plea deal. Typically, in these types of cases, high profile, a couple of girls. I mean, what could he possibly offer him that he would be interested in? So they haven't brought the death penalty. No one could give me an answer on. I don't even think they can get life without parole because they haven't alleged that in a way that would make that an option. So what he's looking at is 2 counts of first-degree murder, which is, I can't remember what the minimum is, but the maximum is 60. But the court could stack those, meaning it would be 120 consecutive. What could he possibly offer him that he'd be interested in taking? So when you have death penalty on the table, you work out a lot of pleas with that. They say, well, if he's willing to take a plea, we'll let him plead to life with or life without, depending on how strong they feel their case is. But what are they going to offer him? Well, if he pleads, he could plead to 60 and we'll run him concurrent, meaning he'll be probation eligible after whatever it is, 20. If he doesn't take it, then he's looking at a true life sentence, 60 stacked to 120, and he wouldn't be parole eligible until he served 80 of the 120, for example. But what could they possibly offer him that they take? Now, I'm sure Indiana is like most states, like Texas, and we've seen this in Idaho with Vallo's husband, Chad Daybill. They brought in Victims' Bill of Rights in Idaho, which is much stronger than most states, by the way. But typically, Victim Bill of Rights in most states, the prosecutor has to keep the family up to date on the developments. They have to advise the family if they're going to offer a plea, get the family's input. Most states, family can say, we don't want you to go after the death penalty. And, we're totally against it because of religion. We don't want you to seek the death penalty. DA is free to seek the death penalty over the family's objection. We don't want anything except life on this. Their DA is free to say understand, but they're free to negotiate what they want. In other words, DA is not bound by what the family's wishes are typically, but the number one thing an elected official does, unless they know they're going to be retiring, is to not blow it and get elected again. So what for you guys know this town and this situation much, much better than I do. What could the state possibly offer to the defendant that isn't going to cause problems for the DA next election cycle, and that the defendant might be interested in taking? Can you all think of anything? I can't.
No, that was my thought too. I know that Sleuthy had something that she was thinking too.
I got nothing.
So it's no different, and please forgive me, I'm not trying to trivialize what's happened in this case, but it's no different than selling a used car. And it's well, you want 15,000 Kelly Blue Book or whatever they use in your neck of the woods. It says 12, but but I got a really bitchin' set of chrome wheels, and I got pinstriping on it, and I got this and that, so I want 15. And your tires are starting to rub and wear, and and you end up with a price. But plea negotiations, you're going in and you're pointing out the problems, and sometimes it's unknowns. Well, I'm getting ready to file a motion, Nick, on your tool mark evidence. I think you got some real problems on that, and I'm going to file that. Man, if that gets granted, you're toast. Well, it's already been ruled on, but there's other motions. So, I mean, it's possible that some of these motions maybe got the DA to think, maybe the family. I understand all of the major principals of the girls' families were there. They heard some things, may have said, hey, we would not be opposed if he was willing to do this. So, I mean, that can happen.
Okay, so can you talk about that Richard Allen? So there's commentary that Richard Allen is not allowed to change his plea because his attorneys won't let him.
That's bullshit. I think I know where I've got a pretty good idea where that came from.
Okay, that's why I said you want to put out.
Somebody's never represented a criminal defendant in a major high-profile trial. He can go in there. He's going to be arraigned in front of the jury, and they typically. The prosecutor reads the indictment or the charging document, or the clerk does, and then the judge looks at the defendant. How do you plead? And it's either, guilty, not guilty, or sometimes when it's a clear case of guilt and we don't want the defendant saying not guilty and impacting his credibility, we use a thing called judge. The defendant stands on his right to remain silent, and the court says, okay, I'll enter a plea of not guilty on his behalf. But he can stand up and say, Judge, I plead guilty. No one is going to say, well, you can't do that. So, I don't know if somebody misunderstood, but no, the defendant can change his plea, but why would he? Okay, so that's the next thing. And I've seen things that, I've got it on good authority that he turned down a plea. Well, when? And what was it? We'll plead him to the max on both, run consecutive. It's not a plea offer. A plea offer is something less than the maximum. And so I don't know where people are getting that from. Go ahead.
But if Richard Allen wanted to plead guilty, he wanted to change his plea right now, how many ways can he go about changing his plea?
He just has to do it. His attorneys cannot stop
tells
him
his,
from doing it.
tells his attorney, I want to enter a guilty plea. But attorneys don't prevent that and say, the defendant calls him up and says, I want to enter a guilty plea. They say, no, we're not going to let you. The client has an absolute right. They have about 3 or 4 things that they have the absolute right to determine, and the court asks the defendant on those things, do you want a jury trial? Do you want to waive a jury trial? Only the defendant can waive that on the record. Judge, I don't want a jury. What plea to enter? Whether they're going to testify. Those are all decisions only for the client, based on the recommendations and advice of their counsel. Everything else is up to the attorney. We try and listen to what, well, I want you to call, I want you to call this person. I want you to call Sleuthy and have her come in and tell you about everything she's found in her research. No, we're not going to call Sleuthy. Sorry. Well, no, I really want you to call Sleuthy. That's up to the attorneys now, which is why if you have a chance and you have Apple TV, watch Presumed Innocence, the series on Apple.
Yeah, I watched that. It's good.
Because there's some conversations in there about the defendant, who's a lawyer, having serious disagreements about the strategy of the case. And it's very true to life about the conflict. And I'm not going to give anything away, but what's great about that series is the legal aspects of it, the conversations between the client and the attorney going into trial, what the other side's doing, what are they up to, very, very realistic. So, and nobody's going to know. They might think they know, but nobody's got an inside track on that Richard Allen has been requesting his lawyers to change his plea, and they won't do it. That's a plot of a movie, by the way. Can't remember which one. And, and it's different, but it was kind of the premise of the that recusal hearing with the thug trial, they had that private meeting, and they probably had that private meeting because they didn't think things were getting communicated to whoever that witness is. Is that little D? Anywho.
Are you talking about for the
So
thug trial?
yeah,
I don't. Yeah, I've not really followed it.
I don't recall. Anyway, so that kind of off the point, but
Yeah, that shit's crazy.
You're following that one?
but it's very, very interesting. Anybody saying, I have it on good authority that he turned down a plea, that's either leaks through the DA's office or could be leaks from defense team, but seriously doubt that. So that would be coming through prison communications potentially, but absent a communication privilege breakdown, that's just stuff that's not discussed. And name another super high profile case that that got resolved that didn't involve, that involved only one person charged. You see stuff with co-defendants where one pleas out all the time, or an offer's made to that person. They make an offer to the least culpable person, the less culpable person of the two, and then they testify against the others. It's pretty common in that type of situation, but you got one defendant. You just don't see offers unless the family is, for whatever reason, and there's a lot of different reasons they might be, that we want you to resolve this case reasonably. We don't want this going to trial. Might be about the lifestyle of the family member. It can be a lot of different reasons. The trauma of going through it, a lot of different reasons, but haven't seen any indication of that so far.
So just to backtrack just a little bit, when we were talking about the jury questionnaire, I did throw up all the names that are listed on there, and it does have the Ron Logan, the Rod Abrams, Elvis Fields, Johnny Messer, Patrick Westfall, Brad Holder, Keegan Klein, and then family and attorneys.
Okay. So if those individuals could be a witness about something in the case, aside from being a potential third-party suspect, so if the state has them listed on their list, for example, as a fact witness about something, they're going to be able to ask the jurors, do they know them? Anybody who's on the state's list of witnesses, it's fair game for the defense to be able to ask, does anybody know them? And then the state, witnesses that might have a reasonable good probability of being called, like the experts, for example. Does anybody know Don Perlmutter? Does anyone know Mr.
Right.
Toolmark?
They do
those
also ask that, like the questions you were talking about earlier about, like, do you have anybody, do you know, or have anybody in your family who works for law enforcement, anybody who does tool marks, or, they go through that whole list too. They have all that in here as well. So,
yeah. So if any of those names are strictly for third-party culprit purposes, if the judge is keeping that issue open, she's going to have to keep the names on. If she's going to go ahead and rule, nope, I don't care what the evidence is, we're not going to discuss these people as third party. There's a problem with that, in that during the course of the trial, if she excludes those names, do you know any of these people? Because that's all it's asking, right, Teresa? It's not saying, have you heard Ron Holder as a possible suspect in this crime? It's just saying,
right.
do
Just
you
says,
know
do you know any of the following people who may be involved in this case?
Who may be involved or who may be called?
May be involved.
Okay.
Well, but it lists all the attorneys too and the family members.
Yeah.
So it's like,
okay.
for
Yeah.
one,
So,
prosecutor.
yeah.
So
yeah. So if she struck those names, and then during the trial, just like with the ATF agent and Karen Reed, enough evidence came on that they let the defense point to the ATF agent as a third-party culprit, based on this motive of flirting with the defendant, I think it was. But they got enough on that they could ask a few questions and make him deny that he was involved. He was the only one. But if that happened and they'd struck the name, she'd have to declare a mistrial, because they weren't able to voir dire, say, well, I think they've put enough on that they can ask questions about Ron Logan, for example. They've shown a nexus. They've shown a direct connection enough to be able to ask at least a few questions. And if she ruled that way, say, thank you, Your Honor. At this time, we need to declare a mistrial. We weren't allowed to ask questions about whether any of the jury knows Ron Logan.
That's a good point.
So they would, because it's such an innocuous question. Do you know Travis Williamson? Do you know Nick McClellan? Do you know all these different people? And it's with a group, police officers and a bunch of different people. They're not going to remember squat about that. But then if they said, and again, she may say, if someone circles that they know some of these potential third-party suspects, we're not going to ask questions in front of the whole panel. We're going to bring them in one at a time to ask about that, just like about Odinism and paganism, heathenism, Sons of Odin, the other ones.
Ferguson, do you have any other questions that you want to ask while you're up here? I know you've been cooking and quiet. She's like, I just put down the phone and I walked away.
Wants to know what wine is good to pair with whatever she's cooking.
It was like ground turkey, I think, is what she had.
Good.
So, I mean, I think that kind of covers everything that we've talked about today, from even the live before into this live. So, yeah.
So, are many people saying they're going to go out and cover that hearing on the 23rd?
I haven't heard anybody. I haven't heard from anybody because it starts at 1 o'clock and the first half of it is closed. So I don't know if anybody's going to take the time to go for the 2-3 hours. No idea. But I do
Yeah,
have a question.
especially after all of the time and expense. It's just last week, right? 3 full days, or is it
Right.
2 weeks?
I think it's 2 weeks now because it was the 30th, 31st, and 1st. But so I have a question. So if I request the transcripts for the upcoming hearing on the 23rd, will they not give me any of it, or will they only give me what was open to the public, or do they give me everything?
They'll have to give you the part that's done in public. Depending on what's discussed in the non-public hearing. What I was going to say until you very astutely pointed out, probably going to be about jury stuff. That is appropriate to be non-public, or the housing or courtroom security, transportation of Richard Allen. Those things are appropriate not to be public. I think you're right. I think it's going to be about jury stuff. Defendants have a constitutional right to an open and public trial, which the Supreme Court has said also includes open and public pretrial proceedings. If it's about jury or security matters, that's going to be a legitimate exception.
Right, and they acted like they don't want the public to know which jail Richard Allen was being housed in. Like Liggett was like, and I'm not going to tell anybody. So
yeah, and so there been a transport order filed yet?
Not yet, not for the 23rd, not that I've seen.
Okay. So one thing I don't know is, is a defendant have a right to come to a status hearing? I don't know.
From my understanding, they don't have to come, but I think that they have to get the judge's approval to not come, right? And I don't know how it is in Indiana, but that was.
Yeah.
I know he's in Cass. I think we all know he's in Cass County, but they made like a big old deal about making like we're not going to tell you.
Yeah. Any motions, anything that's decided, they not only have a right to be there, they have to be there unless there's something like he refused to come, judge, or something like that. And then
I don't think that'll be the case. He's not missed anything.
Yeah. So, but a status hearing on scheduling and whatnot, they don't necessarily have to bring a client in for that. And then if something did get substantive, okay, anything else? We've covered security, transportation, how we're going to do questionnaires, anything else? Well, judge, about this motion in limine I have filed, then, the other side needs to say, well, Your Honor, we're not prepared to talk about that, and our client's not here, and he has a right to be here. Yeah, you're right. Do we need to set that for a hearing and so that Mr. Allen can be here? That's how that would happen. So it'll be interesting to see if a transport order gets issued and how they handle that.
Okay. All right. Well, I guess we'll just keep chugging forward and see what happens. We'll see.
And Andy, you got anything? You've been so quiet today.
Andy said in chat that tiny humans. It was tiny humans, and I know all about it. I got to go give mine a shower so he can go to bed for school tomorrow.
Did they start already?
They started today. So I'm running on empty today. I'm like, I still want to live my summer life. And it's like, nope, you have to go to bed early and take kids to school and pick up kids from school. And that's exhausting.
Yeah, it is. But Um, they're just joy to the world,
They are.
especially
Okay.
yours. You have angels, but I'll tell you that that driving thing, when they got rid of driver's ed in high school, man, oh man.
It's made it tougher, but they do it online now.
I couldn't do it anymore. I had to pay for driving school, get it brought in professional.
Oh yeah, well, so they used to do. Most schools would do the driver's ed, like the paper side, like the learning side, and they actually taught in the high school. Then it changed to where most of them only did like the paper side to like help you get your permit, and then you were on your own for the behind the wheel. Now schools, or at least out here, don't do it at all, and so I had to sign him up for an online one. So he had to do like 30 hours of all these different classes online, and then now he's doing behind the wheel.
Yeah, here you can do certain things, and you have to have so many hours with a parent, and all these different things, 30, 40 hours. And I knew I couldn't live with 30, 40 hours and at my high school, we had those simulator big box things, and there was a movie that was shown, and you had brakes and turn signals and all these different things.
Wow.
And then then we went and you did driving, and we didn't have the cars with dual steering wheels. It's one steering wheel, but he had a brake pedal on his side, and Mr. Burkle Jaces, and I dated one of his daughters, but anyway, that's another story for another time. But yeah, he was, football coach, driver's ed, and a lot of that stuff was funded by like State Farm Insurance and the Chevy dealership. Their names were plastered over everything, but all the movies were by the Insurance Institute and so on. I was a much better driver and much further ahead going through that than our son with my limited teaching skills. And I think it made for safer drivers out of the chute, but I agree. I don't know, but good luck with that. I feel for you.
And it's only my first one to do it, so I have to do this 2 more times in my life.
Wow. And then and she's starting that now, right?
So my oldest is my son Jacob.
Okay.
He turned 16 yesterday. My daughter is 13, almost 14 next month. And so I only have 2 years before she's doing the same thing. The little is only 7. So I've got a little bit of time. I have a little bit of time left there.
Yeah. Well, I hope we answered everybody's questions in the chat. Thank you for inviting me to do this again. I have fun, and
I love it.
Hope to make it entertaining. And again, the disclaimer, just because we're trying to add a little levity to it, we're not suggesting in any way, shape, or form that it's not serious case, and that it's not any reflection on the girls or their families. It's just a way of trying to make a cold hard transcript somewhat bearable. And that's all I had to say on that.
Yeah, it's absolutely facts too, because it does sometimes we get a little off the cuff, or we kind of chuckle, and it doesn't take away from the serious of the crime. It's just trying to, and some of them, like tonight's was super easy, but some of them get really long. So it's just trying to get a little bit of humor while trying to read through it, so that people also follow along better that way. And that's what you guys, the viewers, have mostly requested, is it's easier to like tell who's doing what and who's saying what the way we kind of do it. So
yeah, and if we can get the audio recordings, which we'll talk about later, but you can get more of that inflection, and we'll just play those and pause it, and we'll have a much better idea about the dynamics in the courtroom, because there's obviously dynamics going on. This honeymoon hearing in November, and then moving forward to the transcript from the in-camera discussions, to this last hearing. It's clear to me the dynamics are ebbing and flowing.
Oh yeah, and everybody said they seem to be getting along better now, which is probably they have full teams of attorneys, so there's a little bit less stress on them. I shouldn't say there's not a lot, but a little bit. So that they're kind of putting things out to each other, and it seemed to be better according to everybody that was there. So, I mean, hopefully, and they're apparently emailing each other again. So that's always that's a sign that they're headed in the right direction.
Sorry,
Yeah,
I'm back now.
sure.
Yeah. So do you have anything? I'm going to wrap it up. Do you have anything that you want to add? I know you were busy with your tiny humans.
No, yeah, sorry about that.
No, you're fine. That's my life. I get it.
No, I mean, I think I want to say thank you for having me up. It was like super last minute, and I was totally freaking out about setting all of my electronics up and stuff, and then thinking about dinner. And like Baldwin had, I don't know what, 3 lines. So that worked out well.
You did great. You did good. It was a little one tonight, but now I mean that's a good way to get your feelers in there. And then when we got the big ones coming, we're gonna need all the help we can get.
I'll see if I can scope out a voice changer in case I get called into court again.
All right. Well, thank you both so much, and Sleuthy, who gave us the good old Irish goodbye that she sometimes does. We love her anyway. If I send out the goose signal, I'm sure she'd be back. But we're done for tonight. I did a 2-hour, almost 3-hour live earlier, and now another 2-hour live. I'm like, okay, I think I'm done. I'm done delphing for the day. We'll be back tomorrow. But thank you to you guys for coming up here and reading and just the comedy of sometimes what happens when we try to read these together. It's incredible. But thank you both for being here. I appreciate it.
Likewise. Thank you guys. Thanks everybody in chat. I'll see you guys later. Have a good night.
Yeah, you too.
Good night.
And
you're welcome. Always a pleasure on your channel, Teresa. Thanks
I just
for inviting
appreciate
me.
your insights always. You're just always so good and kind and generous to me and helping me when I have questions. So I just appreciate you.
Oh, you're more than welcome. Thanks for including me. Everybody in chat, good to see you. It's hard to follow along, but I see a lot of friendly faces and
Got the good folk here.
yeah.
And to those good folk, I appreciate you guys too. As always, I know that you guys have 1,000 other places that you could spend your time, yet you choose
I've been
to spend
kicked
your
out
time
of most of those.
Did you heard my last one where I was like, well, since most of you guys have been kicked out of all the other ones, I guess you don't have anywhere else to spend your time. So, all right. Good night, everybody.
Do you dare to follow me down? Head into the unknown. Down the rabbit hole. Where it stops, no